Thank you so much for the kind introduction and the warm welcome. It's truly my honor and great pleasure to be with you. Speaking to high school and middle school educators is always very special to me. If you had talked to me at any point in college, I would have told you that what I wanted to be was a high school social studies teacher. I took all of the classes when I was in college to get my teaching certification. I did my student teaching at Highland Park High School in Illinois. I filled out the paperwork and became a certified high school socials teacher in Illinois. Then I went astray and went to law school. What I was asked to talk to you about today is what every student should know about the Constitution. One of the things that I'm fortunate enough to do is regularly speak at middle schools and high schools in my area. And of course, I want students to know about separation of powers and checks and balances. I want them to know about basic rights like freedom of speech and equal protection. But I'd summarize for you, more generally, 5 things that I hope that every student would know about the Constitution. Let me describe these to you and then save a few minutes of our time for your questions. First, I want every student to think about why have a Constitution? One of those basic questions, when I talk to students at any level, middle school, high school, college, law school, is the question, how is the Constitution different from all other laws? And the answer that I want the students to come to is that the Constitution is different from other laws because it's much more difficult to change the Constitution. Any law passed by Congress can be changed by Congress. Any statute adopted by a state legislature can be changed by the state legislature. Any ordinance that's passed by a city council can be repealed by the city council. But as you all know, the Constitution is very difficult to change. Article 5 specifies the procedures, and the only one that's ever been used is that it requires passage by 2/3 of both houses of Congress and then ratification of 3/4 of the states. Since 1787, there have only been 27 amendments passed. Since 1791, when the Bill of Rights was adopted, there were only 17 amendments. So then I always ask the students, why should a nation that sees itself as a democracy, that believes in majority rule, be governed by a document that's so difficult to change? None of us, of course, were alive when the Constitution was written. We didn't get to vote on whether it should be adopted. Relatively few of us even had ancestors in the country at that time. The answer that I hope the students will come to is that it's desirable for a society to put its most fundamental commitments in a document that's difficult to change. That the framers knew from the history of the world that in times of crisis, there would be a temptation to centralize power. So they wanted to make sure that separation of powers and checks and balances were placed right in the Constitution. I always want my students to see that part of the elegance of the Constitution is that it generally takes 2 branches of government to do anything. Obviously, to adopt a law requires that Congress and the President be involved. To enforce a law requires that the executive bring in action and that the courts convict. To appoint a cabinet member or an ambassador or a judge requires the President nominate and the Senate confirm. Even to get a search warrant requires that 2 branches be involved. The executive to seek it, the judiciary to uphold it. And the framers put that in the Constitution because they wanted to make sure that no matter what the crisis, these checks and balances be enshrined. Likewise, they wanted to put our most basic rights, freedom of speech, free exercise of religion, the right to be free from unreasonable search and seizure, the privilege against self-incrimination, the prohibition of cruel and unusual punishment, in this document that's very difficult to change. Harvard professor Lawrence Tribe said that in this way, the Constitution is an elaborate edifice to make sure that our short-term feelings don't cause us to lose sight of our long-term values. Especially when I talk to high school students who might have read part of Homer's Odyssey, I go to the story of Ulysses and the Siren. And even if students have never heard of Homer or the Odyssey, Still, I think it's a powerful story to illustrate what the Constitution is about. In Homer's Odyssey, there's the tale of how there was a siren, through a beautiful song, would lure sailors to crash into the rocky shoals. Ulysses had his sailors tie him to the mast. He had the sailors plug their ears with wax so they wouldn't be lured by the siren song, but he was able to hear it. The point of the story, the point of the analogy, is that the Constitution is the way that society ties its hands to make sure that we're not lured by the siren song of a crisis. Now, if students see this, they see something enormously important about the Constitution. They realize that it's an inherently anti-democratic document. You don't usually need a Constitution to protect what the majority in society wants to do. They'd be able to do it without the Constitution. We especially need the Constitution to protect minorities in society, to make sure that the majority, out of the passions of the moment, doesn't oppress minority. For the framers of the Constitution, the minorities they were especially concerned about were political minorities, religious minorities. Today, we would speak of racial minorities, sexual orientation minorities. But the idea is the same. The Constitution exists to restrain the majority. The Constitution is anti-democratic. And so I ask my students at the beginning of any constitutional law class, whether I'm teaching undergraduates or law students, to think over the course of the course whether the Constitution has succeeded in its goals or whether it's failed. Of course, the answer is going to be both. It succeeded in some ways, at times it's failed. But I want the students to be constantly thinking about that as we discuss constitutional law. The second thing that I think is so important for students to know is that the Constitution and its protection of rights and equality applies only to the government. Private conduct does not have to comply with the Constitution. When I speak to middle school and high school students and I take their questions, a remarkable number of them can be answered by reminding them that the Constitution exists to limit government. The Constitution is all about creating government and restricting its powers. The Constitution isn't about limiting what private actors can do. I always give a couple of illustrations of this. One is that before taking my current job, I was a professor at Duke University in Durham, North Carolina. Duke is a private university. I always say, when I was at Duke, if I was to give a speech criticizing the president of Duke, or I guess I should say again criticizing the president of Duke University, and he were to order me fired, I could not sue him or the university for violating my First Amendment rights. Since it's a private university, the First Amendment and the Constitution just don't apply. But now, it was pointed out in the kind introduction, I'm at the University of California, Irvine, a state university. If I were to give a speech criticizing the president of the University of California, Janet Napolitano, or I guess I should say if I were again to give a speech criticizing the president of the University of California, and she would order me fired, I could sue. You can be my witnesses. I would sue. Since it is a state university, the Constitution applies. My other illustration here comes from a true story of a conversation I had with my oldest two children 24 years ago when they were 9 and 6, and we were in a grocery store together. At the time, Diet Coke was giving away free baseball cards, and 3 cards were pictured on the outside of the package. As we went up and down the aisles of the grocery store, my 2 sons were fighting, as they often did at that age, and it was about who was going to get the extra baseball card. Finally, I said, be quiet. I don't want to hear anything about baseball cards till we leave the grocery store. My then 9-year-old turned to me and said, you can't tell me to be quiet. I've got freedom of speech. I was ready for him. I said, freedom of speech means that the government can't tell you to be quiet. I'm not the government, so I can. To which he, without missing a beat, turned to me and said, well, you're like the government to me, so you shouldn't be able to tell me to be quiet. True story. It's when I first knew that he was someday going to go to law school. And in fact, he's now a federal prosecutor in Los Angeles. There's only one provision of the Constitution that applies directly to private conduct. That's the 13th Amendment. It prohibits slavery and involuntary servitude, forbids people from being or owning slaves. But other than that, the Constitution and its protection of rights and equality apply to the government, not to private actors. So I always tell students that if you're at a public school, you have some protection of freedom of speech. You have some protection in terms of teachers or administrators looking at your purse or your backpack. But if you're at a private school, the Constitution and its protection of freedom of speech, its protections with regard to search and seizure, simply don't apply. Of course, that doesn't mean other laws don't apply. It's important for students to recognize there are many sources of law. The Constitution is one source of law. The example I always point to my students is race and sex discrimination. If the government discriminates on the basis of race or sex, it can be challenged as violating the constitutional guarantee of equal protection of the laws. But if a private corporation, no matter how large or how small, discriminates based on race or sex, that doesn't violate the United States Constitution. But Congress has passed statutes that limit private employers from discriminating on the basis of race. Congress has passed statutes that prohibit private hotels and restaurants from discriminating based on race. Many states have their own laws that prohibit race and sex discrimination. So it's important that students see that one source of law is the Constitution. It's primarily focused on limiting government, but there are many other sources of law that regulate private conduct. I am constantly surprised by how, to the general public, people don't understand that the Constitution just limits the government. Not too long ago, I got a call from a Los Angeles Times reporter. The Los Angeles Dodgers wanted to increase the drug testing of the players. And he said, doesn't this violate the Constitution? And I said, no, the Constitution doesn't apply to the Los Angeles Dodgers. It's a private entity. And the reporter's exact words to me were, are you sure about that, Professor? That's why it's so important that students understand the Constitution limits the government. Third, students should understand that virtually everything in the Constitution was a compromise. At the Constitutional Convention in Philadelphia in 1787, there was little agreement about anything. I worry that students at all levels take the Constitution almost as if it was divinely inspired, if not divinely given. But that's an enormous mistake. And so I want them to see, in ways that affect us today, the Constitution was a compromise. And there's many of these things that can be pointed out to students as they learn about the Constitution. At the Constitutional Convention, there was a major disagreement between larger states and smaller states in terms of how to structure Congress. The larger states, in terms of population, wanted representation to be allocated on that basis. The smaller states wanted each state to have equal representation. And so, as you know, they compromised. They created two houses of Congress, one on the basis of population, the House of Representatives, one where every state would have equal representation. Or to pick an example that's quite relevant right now, there was dispute about how to choose the President of the United States. Some wanted the President of the United States to be chosen by the people in direct election. On the other hand, there were many at the Constitutional Convention who deeply distrusted the people. They didn't like the idea of majority rule. And so there were proposals to let Congress choose the president, as exists in a parliamentary system. One of the proposals was to let the state legislatures choose the president. But relatively late in the process at the Constitutional Convention, they came to the idea of an electoral college, leaving it to each state to choose electors who would then choose the president. 4 times in history, most recently in 2000, The candidate who won the popular vote did not become president because of the Electoral College. And if I were teaching middle schoolers or high schoolers right now, I'd want them to understand the Electoral College, why it exists, and why it's been impossible to change. But most of all, when I want students to see that the Constitution is a compromise, I want them to understand the choices that were made with regard to slavery. Long ago, early in the 19th century, Alexis de Tocqueville wrote that race was the tragic flaw upon which the American government was built. Race was a central issue at the Constitutional Convention. It was clear that the Southern states would never have ratified a constitution unless it protected the institution of slavery. I always ask my students, and again, no matter what their level of education, I always ask them, if you were at the Constitutional Convention in Philadelphia in 1787, and if you believed that slavery was deeply abhorrent and wrong, would you have still ratified a constitution that protected the institution of slavery? Would it have been better for the country to divide into two or more separate nations? Perhaps to have a northern nation where slavery was prohibited and a separate southern nation where slavery was allowed? The choice was made through compromises to institutionalize slavery. And students should have no mistake. The Constitution did institutionalize slavery. In terms of representation in the House, it says its total population, but there was then a debate what to do about slaves, and they would count as 3/5 of a person. Article 4 contains the Fugitive Slave Clause that says that if a slave escaped from a slave state to a free state, the slave had to be returned. Article 5 that deals with amendments says only two things couldn't be changed by amendment. And one of them was that Congress could not ban the importation of slaves for at least 20 years. And so the choices that were made with regard to slavery had enormous implications for American history. They have implications continuing to today. Fourth, I want my students to see that the Constitution inevitably and inherently must be interpreted. Again, I think the temptation of students and the general public is to believe that the answers to constitutional questions today can be found just by looking at the document itself. But what they need to see is what John Marshall declared long ago in McCulloch versus Maryland, where he said, we must never forget that it's a constitution we're expounding. Constitution meant to be adapted and endure for ages to come. And so I try to get students to see many reasons why the Constitution has to be interpreted, why the answers can't be found in the words themselves. One reason for this is there are many crucial issues that aren't addressed in the text of the Constitution. Example, do courts have the power to declare unconstitutional statutes and executive actions? There's nothing in the Constitution that creates the power of judicial review. You'd search in vain from the debates of the framers in Philadelphia in 1787 to find authority for this. This comes from John Marshall's decision in Marbury versus Madison. Over the course of American history, many, including now, dispute whether Marbury versus Madison was correctly decided. It comes from the court interpreting the Constitution, not from anything in the text of the Constitution. Can the president fire cabinet officials? The Constitution talks about how the cabinet is appointed, but it doesn't say anything about whether they can be removed. Of course, this led to one of the most difficult and important constitutional crises in American history. After Andrew Johnson became president following Abraham Lincoln's assassination, Congress passed the Tenure in Office Act that made it a crime. In fact, it said it was a high crime or misdemeanor for the president to remove any cabinet officials. That led the cabinet to be openly contemptuous of the president, knowing they couldn't be fired. Finally, Johnson fired the Secretary of War, Stanton. Within days, the House of Representatives passed articles of impeachment. Did Johnson act constitutionally in being able to fire the cabinet? Or did Congress have the authority to limit that? You can't find the answer in the text of the Constitution. Does executive privilege exist? Executive privilege is the authority of the president to keep secret conversations with or memoranda from advisors. There's nothing in the Constitution that mentions it. One of the most important constitutional crises during my lifetime centered on this question. There's the case United States versus Nixon in 1974. There, the Supreme Court held unanimously that the president has executive privilege, even though it's not mentioned in the Constitution, but it's not absolute, and the court ordered President Nixon to produce the Watergate tapes. The reason I think that case is so important is that it shows no one, not even the president, is above the law. So in part, the Constitution has to be interpreted because there are just things it doesn't speak to. The answer has to come from interpreting the document, but the solution isn't found in its words. Also, the Constitution has to be interpreted because it's intentionally written in broad, open-ended language. What's cruel and unusual punishment? First case that I ever argued in the United States Supreme Court, a case called Lockyer versus Andrade, involved my client, Leandro Andrade, who was sentenced to life in prison with no possibility of parole for 50 years for stealing $153 worth of videotapes from Kmart stores in San Bernardino, California. He received this sentence under California's three strikes law, even though he never committed a violent crime. In fact, before California's three strikes law, no one in the history of the United States had ever received a life sentence for shoplifting. Is that sentence cruel and unusual punishment? I won in the Federal Court of Appeals, but the Supreme Court 5-4 ruled against my client and said it wasn't cruel and unusual punishment. Is the death penalty inherently cruel and unusual punishment? Just a year ago, Justice Breyer, in an opinion joined by Justice Ginsburg, in a case called Glossop versus Gross, strongly argued that the death penalty is inherently cruel and unusual punishment. Certainly an issue that students at all levels can debate. What's due process of law? What's a law respecting the establishment of religion? What's speech? Is wearing an armband to school to protest a war speech? All of these are reasons why the Constitution has to be interpreted. But perhaps most important and most subtly, the Constitution has to be interpreted because virtually no rights within it are absolute. And this in itself is so important for students at all levels to understand. Even though the First Amendment says Congress shall make no law abridging freedom of speech, freedom of speech isn't absolute. Whenever I talk with students at any level about freedom of speech, I want them to see that obviously it can't be absolute. It's why Justice Oliver Wendell Holmes long ago said, there's no right to falsely shout fire in a crowded theater. Perjury can be punished even though it occurs through speech. If somebody goes into a bank and hands the teller a note, give me money or I'm going to blow up the bank, it's no defense to say, all I did was speak by handing the note. The Second Amendment. Well, it certainly illustrates what I was saying a moment ago with regard to the ambiguity of the language in the Constitution. As you know, the Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Is this a right of individuals to have guns just for militia service, as the Supreme Court held from 1791 to 2008? Or is it a right of people to have guns in their home for the sake of security, as the Supreme Court has held over the last 8 years? But even if it's the latter, the Supreme Court is clear. The Second Amendment isn't absolute. The government gets to decide who has guns, where they have guns, what kind of guns they can possess. Take equal protection of the law. even the prohibition of race discrimination is not absolute. The government can discriminate on the basis of race if there's a compelling interest and no other way to achieve it. So inherently, constitutional law, inherently the Constitution itself, requires balancing. Now, it might be in the phrasing of constitutional law that there has to be a compelling government interest or an important government interest or a legitimate government interest. But the choice still has to be made of what's compelling, what's important, what's legitimate. This requires choices. This requires interpretation. The answer can't be found in the words of the Constitution. Ultimately, it has to come through interpretation. And so fifth and finally, what I want students to see is that judicial review is essential in order to enforce the Constitution. I want them to see the imperative for having courts there to make sure that the words of the Constitution are carried out. When I've taught college political science classes about the Constitution, I've often begun the first day by having my students read a copy of the United States Constitution and a copy of the Stalin-era Soviet Constitution. And then I give them a reading about the repression, the Soviet Union and the Stalin era, sometimes something from Solzhenitsyn. And the question I always ask the students is, how could it be that their Constitution has a much more elaborate statement of rights than the United States Constitution, but this repression occurred? And the answer that I want them to see is that's because there was no institution in the Soviet Union that could invalidate what the government was doing. I had the wonderful opportunity in 1992 to go to the country of Belarus soon after the collapse of the Soviet Union. They, like so many of the newly independent states, was writing a constitution. And I went with a state Supreme Court justice, a federal district court judge, and another law professor. And I was very mindful that the Constitution in any country is a product of its culture and its times, that you can't impose on one nation the choices made in another. And yet I was very troubled as we were there that they had a provision in their draft Constitution that allowed the government to suspend the Constitution and its protections. That seemed so inconsistent with what I said earlier, that the Constitution exists to limit what the government could do in times of crisis. But we were especially concerned that there was no institution in the government they were creating that had the authority to enforce the Constitution, the power to strike down what the branches of government were doing. And we said it's key that you have judicial review to enforce the Constitution. Interestingly, they rejected our advice, and Belarus also became the first of the former Soviet unions to essentially rescind the Constitution and go back to a totalitarian form of government. This idea that courts are crucial to enforce the Constitution is not new. It was the centerpiece of the reasoning of Chief Justice John Marshall in Marbury versus Madison. He said there that the limits of the Constitution are meaningful only if they're enforced. And if it's not the courts to enforce it, who will do it? Every elected official at every level of government takes an oath to uphold the Constitution. But if Congress and the President choose to adopt even a blatantly unconstitutional law, who's going to be there to stop them, if not the courts? But then I ask my students to evaluate whether the Supreme Court has succeeded or failed in this tremendous responsibility given to it. There are many instances where our courts have failed us, and students should be educated at them. Students should know of Dred Scott versus Sanford in 1857, where the Supreme Court held that slaves are property, not citizens, even if born in the United States, where the Supreme Court declared unconstitutional the Missouri Compromise and helped precipitate the Civil War. Students should know of Plessy versus Ferguson in 1896, where the Supreme Court held that separate but equal is consistent with the Constitution and the guarantee of equal protection of the laws. And the court facilitated the segregation that occurred in every southern state, so many areas of northern states, in every aspect of life. Students should be aware of Korematsu versus United States, where the Supreme Court in 1944 upheld the evacuation of Japanese Americans from the West Coast. 110,000 Japanese Americans, aliens and citizens, and 70,000 were United States citizens, were uprooted from their lifelong homes and placed in what President Franklin Roosevelt called concentration camps. I always ask my students, was it realistic to expect the court to do better than this? I think so, but I'm also aware that justice are a product of their culture and their times. But just as I want my students to be aware of the failures of judicial review, so do I want them to know of the triumphs. I want them to know of Brown versus Board of Education. On May 17, 1954, the Supreme Court so powerfully held that separate can never be equal in public education. The court finally led the way to the end of the Jim Crow laws that segregate every aspect of Southern life. I want them to know about Oberfeld versus Hodges from June 26, 2015, where the Supreme Court held that gays and lesbians have the same right to express love and commitment through marriage that heterosexuals had. And the court held that gays and lesbians have the right to marry in all 50 states and all territories of the United States. I think it's important, as I said, that students be aware of the failures of the Constitution and the failures of this review and its successes. Overall, my hope is that the students will see that over the course of American history, there's been tremendous expansion in terms of equality and rights. Equality for women, for African Americans, for other minorities. Tremendous expansion in terms of the rights we possess, the way in which the Bill of Rights has come to be applied to the states, the way in which the rights protected in the Constitution have constantly been enhanced. It's not all in one direction. There's ups and there's downs. But I guess if I want my students to see anything about the Constitution, it's the words of Dr. Martin Luther King, where he said that the arc of history is long, but it bends towards justice. Thank you. And I saved about 10 minutes for questions. Glad to answer questions about anything. And I think they're bringing microphones.
Hi, I have a question. Since your background is on civil liberties and civil rights, what are your thoughts on the legislation that was passed involving transgender students in restrooms in public schools?
Okay. And this is a great topic to talk with students about. Let me be clear in terms of what's the legislation. I'll tell you what's happened so far, including in the courts. As you probably all know, Title IX says that educational institutions that receive federal funds cannot discriminate on the basis of sex. Title IX has been crucial, for instance, in equalized funding for girls' and boys' sports teams. The United States Department of Education, in a couple of letters, one that was released in January of 2015, and another titled Dear Colleagues, released jointly with the Department of Justice, said they are interpreting the prohibition of sex discrimination as prohibiting discrimination against transgender students with regard to access to restrooms and to locker rooms. So there's no statute that prohibits discrimination against transgender students at the federal level. It's an interpretation by the Department of Education, Department of Justice, of Title IX. There was a case, Gloucester County Board of Education versus GG. It involves a student in Virginia who was transgender, born biologically a girl, at age 12, identified as a boy. Between the freshman and sophomore year of high school, changed the first name and changed to the use of the male pronoun, wanted to use the boys' restrooms in the school. The school said no. They said that the student could use a restroom in the nurse's office. The parents felt, the lawyer felt that that wasn't sufficient because that would be stigmatizing. The school board then passed a resolution that said that in terms of restroom facilities and locker room facilities, it has to be corresponding to the birth biology of the child, and that they would create 3 unisex restrooms. The student said, no, that's not sufficient. The student wanted to be able to use the boys' restroom, and a lawsuit was filed. The federal district court ruled against the student. The United States Court of Appeals for the Fourth Circuit reversed and ruled in favor of the student. It was a 2-to-1 decision, and the Fourth Circuit said that discrimination on the basis of sexual identity is sex discrimination, and that this therefore violated Title IX. The Supreme Court has stayed that pending a determination of whether to hear the case, and in October, the Supreme Court justice will decide whether to hear that case or not. Meanwhile, a federal district court judge in Texas issued a nationwide preliminary injunction against the Dear Colleague letter that was issued on May 13, 2016, from going into effect. And so that's the posture of the issue. I think it is a question of equal protection. It's a question of statutory interpretation. Does a prohibition of sex discrimination include a prohibition of discrimination on the basis of sexual identity? My prediction to you is that ultimately the courts are going to rule that discrimination against transgender students does violate federal law, that the position of the Department of Education and the Department of Justice is going to be upheld on this. They'll all quickly get used to it, as the country's gotten used to marriage equality, and that it's not going to be the issue that's going to dominate headlines far into the future. But that's the procedural posture where the case sits right now.
Thank you. Good morning.
Good morning.
I'm curious what suggestions you have for encouraging teachers to teach some rather controversial cases that they may be hesitant to bring up, such as Burwell, which you brought up before, Citizens United, the Hobby Lobby case, Hodges you brought up before, I'm sorry. Sure. What steps could teachers take to bring those into the classroom to encourage discussion without it moving past into something that could become rather fiery?
I feel presumptuous answering that question because you're all very experienced teachers, and I'm sure that you, like I, always want my classroom to be a place where all views can be expressed. And I try from the first minute of the first class in every course to try to create an environment where students are going to be very comfortable speaking up, where I assure that every student that his or her views are going to be treated with civility. But I want to use the words you used at the end. I want fiery discussions. I want students to really care. And I try very hard in any class, no matter what level of students I'm teaching, to try to relate the issues to them. I want them to see that what the Supreme Court does, what the Constitution speaks to, affects them, often the most important and intimate aspects of their lives. Now, for some of the issues that you mentioned, it's going to be much more ideological and less personal. Citizens United versus Federal Election Commission says that corporations can spend unlimited amounts of money in election campaigns. I would hope the students would care about that, but that's somewhat removed from their lives. When you start talking about contraception and abortion, and Hobby Lobby, the case you mentioned 2 years ago was about contraception or abortion, now all of a sudden it's touching their lives in a very direct way. So what I want to do is let the students know that they can express their views no matter what, and we'll treat them civilly. But let me try to be more specific. I look for ways to structure the discussion of controversial issues to make it a productive conversation rather than just the expression of emotions that's less to be productive. So let me tell you how I teach about abortion to the students. And obviously, when I teach constitutional law, I have to teach Roe versus Wade, and the students all come in with deep feelings on abortion. I begin by suggesting to them that I can identify 5 different approaches the court could have taken in Roe versus Wade. And I list them for the students. And very quickly, in case it's useful, one is the court could have said that human life begins at conception, that the word person in the 14th Amendment protects the fetus in the moment of conception, and laws that prohibit abortion are therefore unconstitutional. The laws that allow abortion are therefore unconstitutional. The Constitution prohibits abortion. Second, the court could have said that this is a matter that's left to the political process, that states should be able to do whatever they want. The Constitution doesn't speak to the issue. Third, the court could have said that laws that prohibit abortion deny equal protection, that deny equal protection to women, obviously affecting women differently than men. They deny equal protection to poor people because wealthier women were much more likely to be able to travel to a place where abortion was legal. Fourth, the court could have said that the right to privacy in the Constitution protects the right to abortion, and that women can have abortions up to the point of viability, where the fetus can survive outside the womb. That was the approach of Roe versus Wade. And fifth, the court could have said that abortion is always a private moral choice, and that a woman should be able to remove the fetus from her body at any point in the pregnancy. We don't force people to be incubators or even to donate blood to save the life of another. And I begin by identifying those 5 options, and then I structure the conversation of abortion by asking the students, what are the arguments for and against each of these approaches? What would be the implications if the court took the approach? And so every student can say whatever he or she wants about the topic of abortion, but I've structured the conversation so that I think it's most likely to be useful. And I'll often do that with regard to topics. Choose how I structure it so as to lead the discussion, what's more likely to be a constructive way. But the bottom line is, I want there to be fiery discussions. I want students to care about this because it really does affect them.
Chemerinsky, thank you
Oh, thank you. My pleasure. Thank you. Thank you.